Hello, viewers. Good afternoon. And my name is Esther, and welcome to my debut show on this platform, Insights on Exhibitors Legal. I'm excited about this platform because it gives me the opportunity to be able to share my knowledge with you, particularly in the area of my passion, under the law. We'll majorly be discussing on this platform and enlightening one another about different aspects of commercial law. Our major focus will be on international commercial law, and there will be comparative analysis of what is obtainable here in Nigeria compared to similar jurisprudence in certain parts of the world. I hope you will enjoy this ride with me in our different series. Thank you. Today, for starters, we'll be discussing alternatives to dispute resolution, alternative dispute settlement techniques. I'm a lawyer by training, but honestly, I really don't like going to court. And I know for so many of our viewers out there, you really don't want to spend 10 years in court on a case at the end of the day that could be appealed down to the Supreme Court, and yet you spend 25 years on a land matter. Yes, I share your sentiments as well. I used to go to court. I do litigation in my earlier career, and I do understand the nitty-gritty of these things and how cumbersome litigation can be. However, the law has given us different escape routes from litigation. We have different ways in which we can resolve our disputes, and we'll be enlightening our viewers about these things. That it's not just about going to court. You can resolve disputes with different other techniques apart from the courts. Like I said earlier, this platform is going to majorly focus on different aspects of commercial law. And in commercial law, we have different commercial agreements. Commercial law basically dealing with trade deals, business deals, transactions between businessmen, entrepreneurs, multinationals, company law. So majorly, we're going to talk today, like I said, about alternative dispute settlement techniques. There are different settlement techniques in alternative dispute resolution. We have mediation, we have conciliation, we have negotiation between the parties, and we have arbitration. Our focus today, out of all the different techniques of the alternative dispute resolution mechanism, is going to be arbitration. We're going to be discussing issues around commercial arbitration, both local arbitration and international arbitration. In our contemporary world, when people come into business together, parties draw up commercial agreements between each other. Service level agreements, memorandum of understanding, to put the terms and conditions of the contract into a paper, into an agreement between the parties. All these agreements, trade agreements, service level agreements, memorandum of understanding, they are drafted to collect the intention of the parties on business deals and transactions. In all these forms of agreements, however, there is a common trend in our recent legal involvement. There is a particular clause that is always put in all these commercial agreements, which is the dispute resolution clause. So if you're out there, you want to go into a business agreement with someone and you have to draft partnership agreements or service level agreements, that dispute resolution clause is very key. And most of the time, in the dispute resolution clauses, the major characteristics of it is arbitration. Excuse me. It tells both parties how to resolve the disputes via arbitrating the dispute instead of going to the courts. And it gives different terms of how they can resolve the disputes via arbitration. So basically, as we all know, human relations, disputes are inevitable anyway. And like I explained earlier, it does not make meaningful economic sense to spend years in court litigating a dispute. We can as well go into alternative dispute resolution, under which arbitration is one of them. So, like I said, arbitration is going to be our major focus today. So, what is arbitration? If I may just say, out of all the alternative dispute resolution mechanisms, mediation, conciliation, negotiation, the outcome of these alternative dispute resolution mechanisms, these three, the outcomes are not legally binding on the parties. So, what do I mean? So, parties can decide, well, they have a mediator to resolve their dispute. However, whatever outcome comes out of the mediation, out of the negotiation between the parties, is not necessarily legally binding on them. Parties could still decide to go to court, even after the mediation and negotiation. One party can decide that he's really not interested in the outcome of the negotiation. But it's not so in arbitration. In arbitration, the awards are legally binding. The awards are like the judgments of the court. So, when parties are going into business deals, trade deals, and they have commercial agreements drafted amongst themselves, the dispute resolution clause, which gives them the right to go into arbitration if there's a dispute, also entails the fact that whatever comes out of the arbitration tribunal as an award, which is like a judgment, is legally binding on all the parties to the agreement. So let's delve into what arbitration is. Arbitration is a flexible and consensual means of resolving commercial disputes through a binding and enforceable process. So it's flexible for the parties, it's consensual between the parties. Both parties, or the parties to the agreement, regardless of how many the parties are, have decided to submit to the award of the arbitrator. Parties can choose the institution under which the arbitration will be held, the tribunal, who the arbitrators are going to be. They have that right. And impartial decision makers are the arbitrators, who will not delve only to one side, but will listen to the parties and arbitrate the matter in an impartial manner. These arbitrators, they replace judges under litigation. So, as you have judges in litigation, you have arbitrators in arbitration. They are either selected by the disputing parties or through a mechanism excuse me, agreed on by these parties to form an arbitral tribunal. The purpose of an arbitral tribunal is to collectively bring about a binding decision which effectively resolves the dispute between the parties. So, the arbitrators chosen constitute the arbitral tribunal in this case. And they arbitrate the matter, listen to both sides. It involves a lot of paperwork, actually. Parties come to talk, paperwork are submitted like a court. The only thing is there is a time frame. It doesn't take forever like the normal courts. Excuse me. An arbitration is conducted, like I said, in accordance with the terms of the parties as they have put in their agreement under the arbitration clause. So parties choose in their commercial contracts how they want the arbitration to go. That is part of the effectiveness of arbitration. We're going to look into the valuable characteristics of arbitration, how it helps us as individuals, as businessmen, as entrepreneurs, instead of wasting economic time in court. And I know not all our viewers are lawyers. Our viewers are businessmen, entrepreneurs, people seeking to go into business as well. Arbitration helps when there's a dispute, instead of spending all the years in court because of a business deal. Part of the characteristics of arbitration are as follows. The agreements and the awards. The awards, meaning the judgments of the arbitral tribunal, they are enforceable between the parties. Out of all the alternative dispute resolution mechanism, like I had explained earlier, mediation, negotiation, arbitration, the award is legally binding. The outcome, the result, is legally binding on the parties. So you can take the award of an arbitral tribunal anywhere, and it will be acceptable as binding on the parties for them to move forward to resolve their disputes. Internationally, there are different institutions that regulate international commercial arbitrations. We have the Uncitrall arbitration rules, we have the New York Convention. Those guide arbitration in the international world. So if parties are doing business across board, across the globe, they can submit to arbitration anywhere in the world that they choose to be the place of arbitration. So a businessman in Nigeria doing a business with someone in Singapore, in case there's a dispute, they can have in the agreement that they're going to resolve the dispute in England. And that will be their place of arbitration. We call that lex arbitri in law. We're still going to get to the nitty-gritties of all that. So enforceability of the awards, enforceability of the arbitral agreement is one of the key valuable characteristics and feature of arbitration. Procedural flexibility is another key characteristic of arbitration. International arbitration conventions, like I've mentioned, New York Convention on Uncitrall arbitral rules that regulate some of these international arbitration, and even our national laws, it gives the parties who are in dispute complete autonomy to agree upon the substantive law and procedure that will guide their arbitration. So like the courts, that the rules are already there. When it comes to arbitration, there is party autonomy and procedural flexibility. So parties can choose the substantive law, the procedures that will govern the arbitration. Confidentiality and privacy is another characteristic and feature that makes arbitration very enticing instead of litigation. Unlike proceedings in court, that is in the public record, arbitration proceedings and hearings are conducted in private. Parties are not allowed to expose or bring the press inside the arbitral tribunal. No. Whatever submissions are made, arbitral awards are made, they often remain very confidential, which is good for businesses. Neutrality, one of the most valuable attributes of arbitration, is providing parties with a neutral forum. So parties, like I said, can decide the place of arbitration. They can decide, yes, even though we are doing business in Lagos, our place of arbitration, we want to go to London and arbitrate. So they can choose a neutral venue. It is up to the parties. They are not bound by the place in which they are doing business. Time and cost efficiency as well is also another characteristic that makes arbitration attractive. You don't waste a lot of time. Legal and arbitrator fees, administrative costs, they are less expensive than litigation. Like I said earlier, and as most of our viewers will know, litigation can go on forever. And yet you still pay. You pay for filing in court, you pay the lawyers. Not like that in arbitration. There is cost efficiency. And you can actually decide and have a budget on how much will be spent, even from the very beginning. The arbitral awards as well, they are final and binding. So, when the arbitrators have come together, listen to both sides, parties have filed the papers, everything, they have arbitrated the matter. Whatever outcome, which is the arbitral award, is always final and binding on both parties, which is very, very important. And there's no issue of, oh, we want to go and maybe appeal it to the Supreme Court or something. They are always final and binding. Most of the time, there are experts who deal with arbitration. Not all lawyers are experts in arbitration. And another feature is the expertise and commercial competence that comes with the arbitrators who handle these matters. So when there are complex trade deals, there are people who are specialized experts to hear such cases, which some judges, generally in the general courts, may not be able to understand the nitty-gritty of such commercial deals. So like we have highlighted, many of these characteristics makes arbitration very attractive and interesting in trade disputes. So we want to briefly look at, for instance, currently I'm speaking for Nigeria, and in Nigeria, we have institutions that deal with arbitrations. The Lagos Court of Arbitration is an arbitration institution where parties can approach for resolution of their disputes as contained in the agreements. The Lagos Multi-Door Courthouse explores alternative dispute resolution techniques, negotiations, conciliation, mediation. So those are like, the Lagos Court of Arbitration is majorly the institutional arbitration authority in Nigeria. Institutional arbitration are administered by an arbitration institution like the Lagos Court of Arbitration, and proceedings conducted under the arbitration rules have been drafted by the chosen institution and selected by the parties. So the 2018 Lagos Court of Arbitration rules sets out the framework, the procedure for you to come if you are submitting to arbitration under that institution. There are other arbitrators who are just ad hoc arbitration, and they are not supervised under the institution. So parties can majorly decide which of the institution they want to submit to. If you want to submit to an institutional arbitration, then you'll be guided by the rules of that institution, like the Lagos Court of Arbitration. Or you want to submit to ad hoc arbitration, So you may choose to either adopt a ready set arbitration rules like the untitled arbitration rules, or draw up your own set of rules. And that's where the flexibility comes in for procedures and the substantive law the parties can decide to choose. So basically today, we've been able to talk about alternative dispute resolution with major focus on arbitration, local arbitration, international arbitration. We will be looking more into aspects of international commercial arbitration. The place, how do you choose your seat of arbitration? How do you choose your place of arbitration internationally? What factors do you have to consider? So we'll be looking into different aspects of arbitration, particularly international arbitration, as we continue in this series, and other aspects of commercial law, both local commercial law and international commercial law. So today, I hope you've been able to gather some knowledge about arbitration as a form of dispute resolution, the importance of arbitration clause in your commercial agreements. Thank you very much.